Very much, Mr. Chairman. And Judge Kavanaugh, you can relax for just a short moment because I'm going to take a few minutes at the beginning here and introduce some documents for the record. First, Mr. Chairman, I'd like to introduce and ask unanimous consent to enter an op-ed from the San Bernardino Sun editorial board stating that Brett Kavanaugh nomination might be the calm before the storm. The editorial board says that Judge Kavanaugh is impeccably credentialed, conventionally conservative, and less likely than other shortlisted judges to overturn landmark culture war case law. In addition to his qualifications and nationwide respect, Judge Kavanaugh brings a reassuring image of normality and judicial cohesion. I ask unanimous consent to introduce this document to the record.
Without objection.
Secondly, Mr. Chairman, the San Diego Union Tribune. Why Supreme Court nominee Brett Kavanaugh may be more independent than you expect. This op-ed goes forward to say that it is strongly, the editorial board is strongly inclined to support Judge Kavanaugh's confirmation, has endorsed nominees from both Republican and Democrats in the past. The board advocates for the deference to the president in picking justices so long as the nominee has the requisite credentials, and it applauds Judge Kavanaugh as straight out of Supreme Court central casting. I ask unanimous consent to put this document in the record.
Without objection.
Third, a document from the Harvard Black Law Students Association. This is a letter that exhibits Judge Kavanaugh's commitment to fostering diversity in the legal profession. Last year, Judge Kavanaugh reached out to the Harvard Law School chapter of the Black Law Students Association to express his interest in organizing a clerkship event for their members. Also on the panel with him was Judge Paul Watford, an African-American judge on the Ninth Circuit Court of Appeals. The Black Law Student Association described that event. Judge Kavanaugh explained that one of his priorities is to encourage more students of color to apply for judicial clerkships. Several recent reports have indicated that minority law students are significantly underrepresented in federal clerkships. During the event, Judge Kavanaugh provided his insight and advice on how students should navigate the entire process. They continued, the judge not only graciously offered his time for that panel, but also has continued to mentor numerous Harvard students whom he has taught or worked with in a number of capacities. Again, I submit this document for the record.
Without objection.
Fourth, the Georgetown Prep letter. Judge Kavanaugh's former Georgetown Prep classmates. These men grew up with Judge Kavanaugh. They've known him for 35 years. They know him as a man of high character and intellect before he became a judge, and in high school he was the team captain and a multi-sport athlete. Years later, despite his great achievements, he remains the same grounded and approachable person they knew from class sports and student body activities. Their letter goes on with shining accolades. I'd like to put this letter into the record, Mr. Chairman.
Without objection.
And then finally, for documents for the record, Governor Matthew Mead of Wyoming has sent a letter which states that Judge Kavanaugh embodies the qualities we need in an independent, thoughtful judiciary. He will be an effective and fair member of the United States Supreme Court. I ask to submit this letter to the record.
Without objection.
Well, thank you very much, Mr. Chairman, and Judge Kavanaugh. I'd like to now turn to some questions. Before I get into the questions I had intended to ask, though, I wanted to get into the discussion, go back and try to bring some clarity to the discussion that was held earlier in some of the questioning with regard to the independent counsel versus the special counsel circumstances and laws, statutes that we've had in the United States. My colleagues have asked you a lot about the old independent counsel statute. I think it's important that we walk through some of the differences between that statute, which is now no longer law, and the new special counsel regulation. And I'm going to mention three important differences, and then I'm going to just ask you, Judge Kavanaugh, if you would like to give any clarity to this situation and the issues that were raised with you earlier. First, the process for appointing a special counsel, which is the current situation. The decision to appoint a special counsel and the choice of whom to appoint is solely within the discretion of the Attorney General. The old independent counsel had to be appointed and selected by a panel of 3 D.C. Circuit judges. Second, the scope of the investigation. The scope of the current special counsel inquiry is determined solely by the Attorney General. The scope of the independent counsel's jurisdiction, when it was the law, was essentially boundless, no limits. Third is the process for removing a special counsel. The Attorney General can remove the special counsel for good cause. The independent counsel could only have been removed by a 3-judge panel. I think those are important differences related to the conversations you had earlier. And Judge Kavanaugh, just with that clarification, I'd like to ask you if you'd like to give any more comment or clarification to the discussions that were raised with you earlier.
Thank you, Senator. I appreciate the distinctions, which I think are accurate, and it's important to understand that, as you underscore, the old independent counsel statute had many parts to it that combined to make it such a departure from the traditional special counsel system, all of which were part of the analysis that I think Justice Scalia engaged in his dissent, and that the Congress looked at when it decided that that statute had been a mistake, and you overwhelmingly decided not to reauthorize it in 1999.
Well, thank you. And I felt like you didn't get an opportunity to make that clarification, and that the record needed to be clear for the American people.
Thank you, Senator.
Before we move on from that topic, I just want to state that Eric Holder has noted that the fundamental structural flaws with the old statute. Senator Durbin, as has been said, called that law unchecked, unbridled, unrestrained, and unaccountable. And as we've heard, Justice Kagan has praised Justice Scalia's dissent, calling that law into question. So I just did want the record to be clarified somewhat in that context.
Thank you, Senator.
Now, what I want to do during the rest of my questioning in a number of different ways is to get into your judicial record. I will start with this, however, by going back to what this set of hearings began with yesterday, which was an attack on the documentation that has been produced by you and others for your record. I'll state again, there is no nominee for the Supreme Court who has ever been asked a more robust questionnaire by this committee than you. And you provided, I believe, around 17,000 pages of documents in response to that questionnaire, which was more than any other nominee has been asked. Secondly, you've provided over 440,000 other documents that, or pages, I believe it is, of documents that in and of itself is more than the entire number of documents or pages of documents that were provided by the previous 5 nominees to the Supreme Court. You've also got a record, a judicial record, which is acknowledged by senators constantly as the most important part of the documentation for a nominee to the Supreme Court, of over 10,000 pages of your decisions. And unfortunately, we haven't seen a lot of focus on that yet in the questioning that you've received in this hearing. So I want to try to get into that. Before I do, however, I want to note, everyone has heard this many times, but I'm not sure that the normal American really understands. You are a judge of the D.C. Circuit. It has been said in this room a number of times that that is often called the second most powerful court in the nation. It's a circuit court. There are a number of circuit courts. What is different about the D.C. Circuit Court from, say, the Ninth Circuit Court, in which I sit in Idaho for the Ninth Circuit? What's different between all of the other circuit courts and the D.C. Circuit Court?
Thank you, Senator. All the courts of appeals are important and have important dockets and important caseloads, and the judges on all of those courts do important work. The D.C. Circuit does get more regulatory cases because we are, the D.C. Circuit's in the nation's capital, the seat of government, and therefore more of the administrative law regulatory cases come. So EPA cases, for example, or NLRB cases, EPA, Environmental Protection Agency, NLRB, National Labor Relations Board, Securities and Exchange Commission. We'll get more of those cases involving agencies of the government here in D.C. as a percentage of our docket than you would get in other courts. And that includes some of the separation of powers controversies that traditionally arise of relating to national security cases. We have all the Guantanamo-related cases in our court. So there are cases related to government operations, government separation of powers, administrative law, the agencies that are a bigger percentage of our docket. But I do want to underscore all the courts of appeals of this country do important work, and all the judges have important dockets, and there are different distinctive characteristics or characters of each of those courts in terms of, for example, the Ninth Circuit has a good deal of immigration law, Fifth Circuit has a good deal of that, the 11th Circuit, of course, has a very, all the circuits have an important docket. So I just wanted to not, I want to underscore that D.C. has a lot more separation of powers, but I don't want to, I have a lot of friends on the other courts of appeals, Senator. I don't want to, I don't want to diminish the work that they do, because it's very important work, and what they do as well.
Well, I appreciate your answer, and believe me, those of us who live in the Ninth Circuit understand the power of the Ninth Circuit Court of Appeals, and sometimes we chafe under its rulings, but we are very aware of the incredible power. The point being, though, that the D.C. Circuit is distinctly different, as you indicated, in that it gets a much higher level of caseload dealing with the operation of executive agencies and with operations of government, the kinds of things that we've been talking about extensively here, these types of issues. And I just think it's important for that to be brought out.
Thank you.
With regard to the D.C. Circuit on which you sit, you've spent how many years as a judge on that circuit?
12 years and 3 months.
And how many decisions? Do you know the number of decisions you have participated in?
I think I've handled well over 2,000 cases, including all the cases counted up together.
And how many of those were you the author of the opinion?
I've written majority opinions, published majority opinions in, I believe, 307 cases is the current number.
And there's been some discussion even with the last questioning that you received about what the norm is, what the pattern is with your decision-making. I will note before I ask you this question that the current active judges on the D.C. Circuit are made up of 7 nominees from Democrat presidents and 4 nominees from Republican presidents. So the current makeup of the active judges on the D.C. Circuit is more Democrat than Republican in terms of who nominated them. But I guess I'm going to lead you a little bit with this question, but in this several thousand cases that you have been involved in deciding with this group of judges, what percentage did you agree with? In other words, in what percentage were you in the majority?
It has to be in the 90s, I would believe.
I heard yesterday from the chairman it was 97.
Yes, I believe that sounds correct.
So if there's a pattern here, it's that you are right there with the majority of your colleagues on the court on most cases. And I don't mean just 51%, it's like 90+%, probably 97% if I remember from yesterday correctly.
That sounds about right, Senator. Appreciate it. We're judges. We don't wear a partisan label as judges, and I've tried to work well under the law with all my colleagues.
So those who want to try to create the impression that you are an outlier have to use that last 3%. In fact, I think it's 2.7% in which you are actually in the dissent, or maybe you are a member of a partial majority. But they have to go to that very small number of cases and then try to figure out a way in there to make it look like you have disagreement with norms in the judiciary. I just think it's important for us to note when people start talking about let's look for patterns. The pattern is that you are working with your colleagues on that court in a united way, and that there seems to be a pretty high level, a pattern of a high level of consensus in the rulings in which you participate. In terms of the decisions that you have written, the 307 decisions that you have written, how many of those do you recall? Have you analyzed it? How many of those were majority decisions for a majority?
The vast majority of those are majority opinions.
So it was a small number that would have been dissenting opinions.
This is dissents and also some concurrences.
And some concurrences.
Yes.
Again, I don't know that you would have these statistics, but I assume some number of those cases were appealed to the Supreme Court. Did the Supreme Court, when your cases were brought to the Supreme Court, the ones that you wrote, were they overturned regularly or were they sustained mostly? Do you know the numbers on that?
I believe there are 13 cases where the Supreme Court has agreed with the analysis that I had, or the decision I had made, either in a dissent or in a majority opinion for the D.C. Circuit.
And how about reversals?
I'm aware of one case where there was a reversal.
Excuse me, so 13 to 1. Again, if you're looking at a pattern, it appears to me that you are, again, in the mainstream of the American judiciary. Mm-hmm. With regard to the question of how the Supreme Court has treated your cases, I seem to recall that they actually adopted your line of reasoning in a number of cases. Is that correct?
That is correct, Senator. I don't know if you have a. Well, I'll let you.
I don't have the number on that.
Yeah, no. That of the 13, that is correct. Where they either cited or quoted or otherwise agreed with the reasoning or decision I had made in a concurrence or dissent, and I'm happy to talk about those. But
well, let me ask you this question, and you can use it there.
Of course, I'm happy to talk about that.
What I was going to ask you next is, before I go into some of the cases that I'm aware of that you participated in that I think are notable, are there any of the cases that you've participated in as a judge, particularly those where you've written the opinion, but any cases you would like to note? Like I said, we haven't really gotten into your judicial record much here. I'd like you to have an opportunity to talk about your judicial record. Are there some that you would like to discuss with us before I go on to some that I have on my papers?
Well, I'll let you ask a few, and if there are any others I want to go to.
Well, I'll probably run out of time before I'm done with mine, but
I'll try to be succinct.
well, the first one is, back to an issue that you've been criticized for, is equal treatment of women. One of the cases I'm aware you participated in is the United States versus Noye, where you defended the rights of vulnerable women and reversed the district court on grounds that a female criminal defendant was prejudiced by her lawyer's failure to introduce evidence of her suffering from battered woman syndrome. Would you discuss that case a little bit?
Yes, there had been a criminal conviction of a woman for extortion, and she claimed duress defense. She claimed that she was a battered woman, that she had been repeatedly beaten by her boyfriend. The district court had ruled against the woman on the claim that her counsel was ineffective by not presenting the battered woman's defense. It came up to our court, and I wrote a lengthy opinion explaining why it was ineffective assistance of counsel not to present the battered woman's defense, over a dissent from another judge, I should add. And I explained the point there that the jurors needed to hear the evidence from the expert about the battered woman's defense, because otherwise the jury might not believe the claim she was making, because they might think, well, why didn't she walk away, or why did she not do something else? And the expert testimony would explain what happens when you're beaten repeatedly, and would explain that the jurors would benefit from having that expert understanding that sometimes you can't walk away. That's the whole point when you're in a relationship where you're beaten repeatedly.
Well, I appreciate that.
And I therefore reversed the conviction in that case that Noy had received.
And the ACLU said your opinion in a way demonstrated a sympathetic and nuanced understanding of intimate partner violence and its effects. I'm going to skip over another case, Adams versus Rice, because we're running low on time. What about Artis v. Bernanke, in which you voted to reverse the dismissal of a Title VII complaint by an African-American female group of secretaries alleging race discrimination by the Federal Reserve Board? Can you tell me about that case?
That's a discrimination case where as we analyzed it, the evidence presented was sufficient to raise a claim of race discrimination based on the treatment that the African-American secretaries had received in that case. And that was our ruling in that case.
Well, thank you. And I've got pages more of cases on this issue, but only 10 minutes left in our time. So I'm going to shift to another issue. Again, looking at cases that you have decided, race and diversity. Let's talk about Ayesi Ito versus Fannie Mae. In that case, an African-American employee was fired from his job at Fannie Mae. He brought an employment discrimination claim alleging his supervisor had used a despicable racial slur and created a hostile work environment. Not only did you join Judge Merrick Garlick and Judge Thomas Griffith in the court's per curiam opinion, but you also wrote a separate concurrence. And in your concurrence, you wrote that the severity of this racial slur, even a single use of the N-word by a supervisor, is sufficient by itself to create a hostile work environment. And I could go on, but I'd rather give you a chance to just describe that case a little bit.
Well, that case was a powerful case. The plaintiff argued it pro se in front of our court, which is unusual. And the situation was that he had been called the N-word by a supervisor. The question was whether the single utterance of the N-word constituted a racially hostile work environment under the Supreme Court's precedent, which says severe or pervasive. So the question really was, is a single utterance of that word severe under the precedent? I wrote a separate opinion to make clear that it was, that word, that no other word in the English language so instantly or powerfully calls to mind this country's long and brutal struggle against racism, which I've emphasized in many cases is the long march for racial equality in the United States is not over. And you look back to I cited some of the history of the country, and the original sin of the Constitution was its tolerance of slavery. Fugitive slave clause, the importation clause, which allowed the slave trade from 1788 to 1808, which during that 20-year period, 200,000 additional slaves were imported into the United States. The history that corrected in part on paper in the 13th, 14th, and 15th Amendments, but then, of course, a century of backtracking from the promise of the 14th Amendment, Jim Crow and racial discrimination, leading up to Brown versus Board of Education, of course, again, and the Civil Rights Act, and the Voting Rights Act of '65, among the most important pieces of legislation ever enacted by Congress in terms of changing America. But still work to be done after centuries of discrimination, racial slavery, racial oppression, racial discrimination. In this case, to my mind, was one case with one person arguing one claim of one incident. But to me, the whole history of the country was represented on race relations, and racial discrimination was represented in that one case. And I tried to capture that as best I could in the opinion I wrote in that case.
Thank you, Judge. And let's move on to Ortiz-Diaz versus the Department of Housing and Urban Development. In that case, you joined an opinion holding that denying a lateral job transfer with the same pay and benefits may be an adverse employment action when the employee alleges he sought to transfer away from a biased supervisor. And in that case, you wrote a concurrence in which you said that the court sitting en banc should establish a clear principle that all discriminatory transfers and discriminatory denials of requested transfers are actionable under Title VII. And you went on to make it clear that denying an employee's requested transfer because of the employee's race plainly constitutes discrimination. And I'll let you go further on that if you would.
Well, the question was, if you're transferred laterally and you get the same pay and benefits, is that really a change? And suppose it's an oral argument in that case. If anyone's interested, I encourage them to listen to the oral argument in that case, where I said something that I explained later in the opinion. Look, in the real world, a transfer, even if you get the same pay and benefits, may hugely affect your later job opportunities, your career track, and to think that discriminatory transfers were somehow exempt from the civil rights law merely because you had the same pay and benefits was blinking reality. And so that's what I said in the opinion. Our case law at that point basically said some transfers can be actionable, others not. And what I wrote was, I don't see how all discriminatory transfers aren't unlawful under the Civil Rights Act.
Well, I think it's important for America to know that your attitude is that strong on this. And we already went over the Artis versus Bernanke case when we were talking about women's rights issues. But this, again, is a group of African-American secretaries who were alleging discrimination, and you ruled in their favor. Again, I have a number more cases on this, but I got a different question on, still on race and diversity. I recall the Black Law Students Association letter from Harvard that I introduced the letter on previously. But I also note here that your commitment to promoting civil rights extends back to your personal law school days when you wrote one of your first pieces of legal scholarship, your law school note, which was titled Defense, Presence, and Participation, a Procedural Minimum for Batson v. Kentucky hearings. Now, what that means, you can explain.
Yes.
But essentially, it was an article about this topic that you chose when you were in law school. And I guess my question is, explain the topic, but why did you choose this topic in law school?
Well, because I was interested in trial procedure at that time, but I was also a product of a city where, as I've described yesterday, and described what my mom did in terms of teaching at McKinley Tech, where race relations and race discrimination were an issue that was of concern to me. And so I wrote, after the 1986 Batson opinion, which prohibited race discrimination in peremptory challenge and in jury selection, I wrote, well, what's to prevent backtracking from that decision by prosecutors who will be able to assert seemingly race-neutral reasons but still have the effect of excluding African Americans from juries. And so I wrote a law review article published explaining that we needed good procedures to detect even subtle discrimination in the jury selection process to ensure that the Batson v. Kentucky decision was not evaded, and so that the legacy of all white juries convicting African American defendants is, of course, a painful part of our criminal justice legacy. And one of the things I wanted to make sure, and the Batson decision came out, was that that was not circumvented procedurally.
Well, thank you, Judge Kavanaugh. I just want to commend you on this, and as I said at the outset, it seems to me that an awful lot of the time in this hearing has been spent trying to create criticisms of you in areas like women's rights or race relations and what have you, when in reality your record is strong and deep in terms of protecting women's rights and protecting those who are in unfavored positions and protecting against racial discrimination. And I hope that we can get a strong focus on your true record, because whether it's these issues, whether it's the independent counsel versus special counsel issues, or whether it's just the balance of your decision-making and whether you are somehow out of the judicial norms in terms of your approach to decisions that you've entered into as a circuit judge, your record reveals the truth. And the attacks that have been made on you today are absolutely unfounded. And I just hope that we can get a much deeper look at your true, honest record as we move forward. Now, I've only got a minute and 12 seconds left. The most important issue to me in your nomination is whether you will be an activist justice or whether you will follow the law as it is written. I know what your answer is, but I'd like to hear you in the last minute that I have. Tell me again, what kind of a judge, what kind of a justice will you be on the Supreme Court if you are confirmed?
Senator, I appreciate that, and I appreciate your comments. I'll be an independent judge who follows the law, Constitution as written, informed by history and tradition and precedent, follow the statutes that you pass, the Congress passes as written, informed by the canons of construction. I will remember Hamilton's admonition in Federalist 78 that the judiciary exercises not will, but judgment, and Hamilton's admonition in Federalist 83 that the rules of legal interpretation are rules of common sense. And I will give it my all, as I've tried to do for the last 12 years as a judge on the D.C. Circuit.
Thank you very much. I commend you for that answer and your approach to it.
Thank you, Senator.